Well, good morning to everyone in Saskatchewan, Alberta, and British Columbia, and good afternoon to everyone for points east. Welcome to this is now our fourth online luncheon. The FOAJ and ADRIA have been hosting online luncheons ever since April, when the COVID pandemic changed our operations significantly. They've been very successful, and I have to say that although we look forward to resuming our in-person luncheons in Calgary and Edmonton, we will probably be continuing with an online series for months, if not years to come. It has certainly allowed us to bring in new speakers from different parts of the country, and I encourage you to keep an eye on our calendar and our websites and come back for future sessions. Each session, in fact, is worth 2 CEE points if you're an ADRIA member with a national designation, or most other professional associations will accept these luncheons as 1 hour's credit towards whatever ongoing professional development programs that that profession might have. On the ADRIA website, you will find recordings of our past webinars, and in the weeks ahead, there'll be a recording of this one as well. But our June speaker was Rai Moran from the National Center of Truth and Reconciliation. In May, we had a panel speaking about MedArb processes and rules. In April, we had a moving presentation from Holocaust survivors about heroism and survival during the Holocaust years. There's also a webinar there on conflict management coaching. So I do encourage you to visit any or all of these if the subject interests you. And of course to our websites for both the FOAJ and ourselves. Our next luncheon is going to be confirmed shortly, but we expect it will be August 11th. So you might want to mark your calendars for August 11th, this same time frame. We're expecting it to be Dr. Darren Lund from the University of Calgary, and he will be talking about opening uncomfortable conversations on social justice in our workplaces. So that's worth noting. The September date is still to be confirmed as the speaker will be, or speakers will be. It'll be on the subject of ethics, ethics in ADR. October 6th is another date worth mentioning. We'll have Julie Durrett from New Brunswick speaking about therapeutic jurisprudence. So these are all subjects that you might wish to take in. So let me take a few minutes before we introduce our speakers to introduce the two organizations that are hosting today's luncheon and the past luncheons. And I'll start by introducing our partners over at the Foundation of Administrative Justice. Karen Popov is one of 2 executive directors there, and she will give you a few words on the work of the foundation. Karen.
Thank you, Paul. Good morning, everyone. Thanks for joining us. It has, like Paul had mentioned, this has been a very successful endeavor with ADRIA and since going through the Zoom course. Just a bit about the foundation and its training. We are here to help decision makers who sit on tribunals and make decisions on other people's lives. We have a certificate in tribunal administrative justice. The certificate assists tribunals and participants to evaluate and support competencies in the administrative justice roles. Since you've registered for this course, you may also be interested in some of our other training. One in particular is effective hearings. We have interpreting legislation, decision making, decision writing, and principles of administrative justice. In the fall, we'll be holding all of our courses through the Zoom platform. We won't be holding any in person at this time. We'll figure that out as the world turns and see what the COVID-19 does. I invite you to come and visit our website. It's up on your screen right now at www.foaj.ca. And I hope you enjoy the presentation today. Thank you, Paul.
Thank you, Karen. Appreciate that. So if I haven't already introduced myself, my name is Paul Conway. I'm the Executive Director for the ADR Institute of Alberta. ADRIA has about 700 members right now, and it is the professional association for mediators and arbitrators and other ADR professionals in the province of Alberta. And we are part of a federation of similar institutes across the country that operate under the umbrella of ADR Canada. So like everyone, we have been impacted dramatically, I would say, by the pandemic, but we're actually enjoying this opportunity to move some of our training online and to host these types of webinars. So We are the only affiliate that offers a robust training program for beginners through advanced practices of ADR. And I invite you to visit our website. It's up on the screen right now. If you're not a member, please take a moment to kick the tires, check out the website, register for a free newsletter, and stay abreast of these types of opportunities as they come up. We do hope to resume some in-person training in September, October, and into the fall under the provincial guidelines. But we have, as I mentioned, moved a lot of our training, or started to move our training as an alternative for those that are not comfortable with the in-class sessions, even with the social distancing. We are starting to move some of our classes online as well. So there is an upcoming opportunity. I think the registrations are still open for a 40-hour ADR communications course that starts in July. There might even be a seat or two left for an in-person training with Cindy Noble of conflict coaching, or on conflict coaching. Cindy is the owner of Synergy, and she is probably the most articulate instructor when it comes to conflict management coaching in Canada. So we look forward to hosting her in person in Edmonton in September, and I think there might be 1 or 2 seats available for that. So before we move on, just 2 more things. First of all is admin instructions. We have well over 200 people online right now, so you will not have an opportunity to ask in-person questions or by voice, but I do direct you to the chat and the Q&A function. We will be favoring the chat. If you can't access chat, then by all means use the Q&A. But the chat function is the best way to send in your comments and your questions. I will attempt to moderate and group questions into themes and pose them either periodically or at the end. There will be polls also and information that pop up on your screen from time to time, so please pay attention to those as it's part of the presentation, and some opportunities there for you as well. We will do a hard stop at 1:15. I assume that we'll be into a Q&A session at that point where I'll be moderating, but there will be a hard stop to the video conference at 1:15. The PowerPoint slides that you see today will be posted and shared with the participants. So you don't, by all means take notes, but we will share the PowerPoint presentations with you. You can, of course, since we're not going to drown out our speakers in thunderous applause, you can express your appreciation by the chat function at any point or towards the end, so please do so. There will be follow-up correspondence and information about future webinars. The PowerPoint, as I said, will be shared, and your feedback will be solicited by email after today's event. Secondly, and lastly, before I introduce our speakers, allow me to first recognize that we have several hundred participants today from across country, or from across Canada. Today we meet virtually, but as individuals we participate on lands previously occupied by our Indigenous peoples. We are encouraged to remember their heritage and history, as well as the important contributions of many races and cultures in our shared history of settlement and immigration in North America. So let us begin by acknowledging that for thousands of years, Indigenous peoples have walked this land, weaving their identity and their spirituality intimately with the land. We acknowledge with respect that we live, work, and play on lands often delineated by treaty or otherwise occupied by settlers. Keep us mindful of the many covenants and treaties that we have made, and often broken, with our Indigenous peoples. And may we find new ways to live with respect on this land together, moving into reconciliation as we journey forward. It's now my pleasure to introduce our speakers today. We have 2, as you know, and I'm sure you've read the biographies, but I will review them. Carol Zakuski will speak first. She is a lawyer and a qualified arbitrator. She's a member of both the FOAJ and ADRIA, based here in Edmonton. Her practice is primarily focused on assisting municipalities and the provincial assessor with property assessment complaints and appeals. She also serves as counsel to administrative tribunals, helping them with determining a fair hearing procedure with decision writing. She appears regularly before a municipal government board, or before the municipal government board, the MGB, composite assessment review boards, and before the Court of Queen's Bench. Carol has been on the staff of several boards. She's also an instructor with the Foundation of Administrative Justice and is appointed to the Payment in Lieu of Taxes Federal Tribunal. So Carol will be the first to speak, but I will also, before she does so, I will introduce Adrian Wright, who is a longtime lawyer, adjudicator, and mediator. He spent many years in the Northwest Territories, 29 years, I think Adrian told me, in Yellowknife, but he has wisely chosen to settle on Salt Spring Island in British Columbia, which is a terrific spot. I know the place well. He has adjudicated claims of sexual abuse and physical abuse involving the Indian residential school survivors and part of the residential school independent assessment process. And he has decided and mediated human rights complaints for the Human Rights Adjudication Panel of the Northwest Territories. He has advised and represented the Registered Nurses Association of the Northwest Territories and Nunavut in registration, professional conduct, and other cases. Workmen's Safety and Compensation Commission of the Northwest Territories and Nunavut. He has decided cases, advised decision makers, and both challenged and defended administrative decisions in court. He is now the Curriculum Development Coordinator and an instructor for the Foundation of Administrative Justice. Welcome, please, Carol and Adrian. And Carol, I believe you're first up.
Yes, hello. Thank you very much, Paul. I am the first, as between Adrian and I, to speak, and we're going to go back and forth between us, and we will try our best to weave in responses to your questions. If you could advance the next slide, please. So when Adrian and I first started working, if you could go back one, please. When Adrian and I first started working on and getting up to speed on the idea of using the different online platforms for hearings, we had a bit of a debate. Adrian falls under the virtual hearings are here to stay exclamation point of view. Then we also thought about, are virtual hearings really here to stay? I think we've both come to the conclusion that yes, they are. There's a great explosion right now, obviously, in using this type of technology. But the more that the two of us have learned about it and worked with it, as Karen mentioned, we've been very busy at the foundation using the Zoom platform for teaching. So I think that the two of us have really settled into that virtual hearings are here to stay. They're now going to be, as most of us get used to this technology, they're going to be another tool in the tribunal's toolbox for giving administrative justice to the participants that appear before them. Next slide, please. If you could put the 3 bullet points up. I think really the only thing that I wanted to say was that the PowerPoint would be available. And one of the things that I think is really useful to you at the very end of the PowerPoint is a couple of pages of resource material that Adrian and I have found, and actually just found another one this morning that we will add. So if you could turn to the next slide, please. So here we have Winston Churchill and a quote attributed to him, "Never let a good crisis go to waste." That came to Adrian's mind when we were preparing, and I think that it's a good description of how administrative tribunals have embraced the virtual technology. Some have embraced, some, that's Adrian, he's embraced it. I am not an early adopter of technology, so I am more in the school of I've been dragged somewhat unwillingly into this world, but now I'm in and I see the benefits of it. The PowerPoint slides was a question. They are going to be posted. We'll deal with that at the end because I just want to make sure I'm giving you the right information. Next slide, please. So here I'd like to test the experience, test the waters with the group that we have. And we've got this is, I think, quite a robust group to check on your experience. So if you could launch the poll, please, and I'd like you to check all of them that apply in your experience. We'll give you all a couple of minutes to So once we have about at least 50% of the people that have voted, maybe give another 30 seconds and then share the poll results, please. Okay, so this is not entirely surprising. Most of us have experience participating in using one of these platforms in a meeting, perhaps in a webinar like this. Some of us have been the host, so that means that we can access some of the additional features like creating a breakout room or perhaps sharing our screen. Most people have not yet had a virtual hearing. Most people are actively participating in a virtual, in planning for a virtual hearing, and a small percent, about just under 20%. So there've been requests to speak a little louder, so I'll do that. About 20% of people have actually participated in a virtual hearing. So I think Adrian and I did a similar webinar a few weeks ago. The response of people was relatively the same. So we're now going to launch poll number 2, please. That will be the next slide as well. So let's see what camp you fall into. Are you in the Adrian camp? Virtual hearings are here to stay, 3 exclamation points. Or my camp, I grudgingly accept that virtual hearings are here to stay. Or somewhere else. So a couple more seconds and then launch the poll, or show the poll results, please. Oh, okay. The majority has embraced the technology, and virtual hearings are here to stay. And then the second is in sort of my perspective that we pragmatically accept that virtual hearings are here to stay. Okay, thanks very much for participating in that. Gives us all a chance to see where we're at. So if you would go on to the next slide, and I think that this is the outline of the webinar discussion points, and I'm going to switch over to Adrian. Adrian, you need to unmute.
So we have about 10 topics altogether we're going to address this afternoon. I'm going to lead off by talking something about technology and equipment. Carol will then speak about security and setting up your background for your, what I will call your virtual hearing studio. I will then deal with advanced preparation and directions to the parties of the hearings. Carol will then come in and talk about virtual etiquette, documents, oaths, and witnesses. I will end with Zoom fatigue and assessing credibility, and Carol come back with checklists and links to other resources. So next slide, please. If we could start then with technology and equipment. Oh, I guess we have a poll first. So should we perhaps launch that poll? And you see we've got a number of responses here dealing with what participants are concerned about in virtual hearings. I'm not seeing the results here, so I'll just kind of guess as to when we should be showing the results.
They should be coming up shortly, Adrian.
Okay, thank you. Okay, so we can see the biggest concern here, amongst many, is technology failures, which I think probably any of us who've done these things are familiar with, and they can cause issues. Very close second is on both unfamiliarity with technology and managing the technology and the normal hearing issues. So we have that issue of finding someone who can manage it, so finding someone who can manage it, or learning to manage it enough yourself so that you can use it effectively. And that ties into the unfamiliarity with technology. Security is an issue for many, though interestingly, I would say if you'd run this poll probably a few weeks ago, I think I would have seen that higher. Let's say a month or two higher. I think gradually we're starting to deal with some of the security issues, and that seems to be less of a concern with people over time. These hearings will take longer. Definitely, there is a concern about that. Having said that, I think we're also finding devices to deal with that, and I think the longer that virtual hearings go on, they'll probably become more efficient, but I'll talk about that in some of what we deal with in a moment. How do we manage documents, and will witnesses be as effective? Two other sort of process type issues that we will talk about as well. So you can see there's a large concern about most of these things, perhaps the least being these hearings will take longer. Okay, so let's just go back one slide to the technology and equipment slide. So first of all, the first item on the list is robust protection for confidentiality. Your first technology issue is going to be sending out a calendar invitation to the participants. As far as confidentiality is concerned, or security, you should remember that, at least in the Zoom platform, which I'm most conversant with, it's best if the password is sent out separately from the invitation. And we're told that significantly enhances the security of the platform. It's important that there be high quality imaging and audio. So imaging, I think we all know that the quality of seeing the person on their side, and I think this is especially important with witnesses, though it can be also true of other participants, it varies greatly with the quality of their camera. So you may want to discuss this issue in case management, because it may very well be very important to what you have to do, especially if you think it matters to your assessing credibility and reliability. In other words, should you settle for what they have, or should you demand more or hope for more because it's going to make a difference to the product? And I can say that personally, the webcam I'm using right now, I purchased since the COVID crisis happened, and I've been told by many that it has a high quality image, and it really wasn't that expensive. So it's something that can be considered. And I noticed Carol mentioned one of the resources is a publication the Alberta Labor Relations Board put out on this topic. And one of the things they have done is to actually have a room available in their facility to allow witnesses to attend. So you could set it up so you have dealt with some of these issues and to improve the quality of the camera. Audio is also important. You should think about it. So for example, if you're using speakers, it could be subject to the acoustics in the area you're using, but many of course will prefer headphones or earphones or audio. Internet, you should also think about 3G, 4G, LTE, 5G are preferred, and better to have hard link as opposed to Wi-Fi, at least 5 megabits per second, generally speaking, more reliable, and so that's, if you can do that, that's probably preferred. Breakout rooms. Breakout rooms are something that you're probably going to want to use, especially if you're using the Zoom platform. They help the parties confer. They help the decision maker confer. You can go in if you're the host, so you can tell the parties that you're doing that. But they're a useful tool to allow some of the things that you take for granted in an in-person hearing to happen. And speaking person, they're very effective. The very effective part of the things that you are available to you. Screen sharing for documents. So I see one person was asking about breakout rooms. Breakout rooms are a feature of Zoom, and I'm told WebEx as well, that allow you to break participants out into smaller groups. They're each confidential. So one group cannot hear what's going on in the other room. It's really like being in a room. But the host can go into any one of the breakout rooms so that it's a confidential way of parties conferring. Screen sharing for documents are an important part of the technology. So they ensure everyone's looking at the same document. You can point out what you need to point out to, and your experience is that it's easier to share the screen than going back and forth. Our experience is it's easier to share a screen than going back and forth between PowerPoints and documents. Recording capability, as you can see, is a nice thing to have to be able to easily create a record and potentially a transcript. And there are also very many good tutorials now being offered by court reporters, facilitators, and so on about using these platforms. And important also to note that each platform may operate differently on various devices, so you should make sure you check these things out before you start your hearing. There's a question about it. Is it just as effective to use the waiting room for Zoom as opposed to the hearing room? The waiting room is really a different feature, and it's a way to sort of park participants. So people who are coming in, it might be better, say, for example, for witnesses, so that when witnesses are about to join the hearing, you put them in the waiting room. The breakout room is more for people actually involved throughout the hearing. So say one of the parties and their counsel would use a breakout room. Probably don't want to put witnesses in the breakout room during the course of the hearing because they have a chance to talk about things with counsel. So really the waiting room feature is better for that type of participant. So I'm going to now turn it over to Carol, who's going to talk about security.
Thanks. If you could advance the slide, please. So I think that Adrian has dealt with the concept of the virtual waiting room. And there was a question, is the waiting room available on WebEx? Yes, I believe it is. I haven't hosted a WebEx meeting. I've been a participant. And when I've been a participant, I've been parked in the waiting room. In a way, you were all parked in the waiting room before the host of the webinar let you into the webinar session. So there's also been a few questions relating to access to justice issues for people that may not have the necessary technology, and concerns around the public. So first of all, if your hearings are open to the public, why would you want to send the public a password and things like that? Well, in your notice that you're going to have a hearing that you would advertise to the public, you would need the people that are wanting to attend from the public to contact the host of the meeting so that they can register their email address, their telephone number, their name with the host, so that the host can send them the link to click to get into the meeting. And a password is a recommended mechanism so that you as the tribunal know who's in your hearing. So I think that even if you have public, the general public attending your hearings, having them register in advance and the use of a password is important, because then you know who's there. Access to justice issues. Well, that I think goes into advanced preparation, and you're going to need to have someone at your tribunal who is the host of the hearing, a staff person perhaps. And one of the jobs of the staff person is to be in contact with people who are going to be participating in the hearing, the parties, the witnesses, public who are going to be observing, and practice with them to make sure that their technology works, that they know how to access the link and can get in and can use the technology. You may need to, just like making accommodation for someone who may need a translator, making accommodation for someone who may need physical access issues. You may need to think about what you can do with that individual if there are other agencies in that person's community that they might be able to go into and, borrow someone's computer for the purpose of the hearing. That advanced preparation is also necessary for dealing with when there are Wi-Fi problems or connectivity issues, which sometimes there are. So it's all about advanced preparation and working with the person to see what you can do. How would you go in camera at a virtual hearing? That's a very good question. Very easily. So the host that sets up the virtual hearing, there is the waiting room, which is like any other waiting room where you sit outside till you're invited in. What we are in now is what I would consider to be the hearing room. And then you see the third bullet point on the screen, a breakout room. The host can create breakout rooms. You would create one for the decision maker and their staff, and only those people can get in there. You would create one for the complainant or the applicant and whoever is they want coming in their room, one for the respondent. And if you excluded witnesses from the hearing until it was their turn to testify, you park them in the waiting room. And the breakout rooms are completely secure. You cannot get into a breakout room unless the host allows you. Nobody can hear what's going on in a breakout room. So it's as if you got up out of your chair at a hearing room, went out across the hall into a physical breakout room. That's what they're like electronically. Okay, next screen, please. And then if you could put the bullet points up. Next screen.
Carol, it's Paul speaking. I'm just going to interject with a comment or a question or something for you to respond to. I don't consider myself an early adopter, but I was using online tools, video conferencing specifically for mediation, 15 years ago. And one of the rules that we had pertained to co-mediators and the importance of, if you have a breakout room or you're going to have a breakout session. We didn't have breakout rooms back then. But if you were going to have a breakout session, you needed to make sure that both co-mediators were in the room with the party in order to dissuade the perception of, this person has this mediator and that person has that mediator. So it was very important for co-mediators, and mediators use these tools as well, to be present in the virtual breakout room, both of them with the parties, even if the co-mediators are not physically together. Yeah,
absolutely. And you would just do that by the list of people that are able to go into breakout room number 1. And you would have the co-mediators as able to go there. There's a question, is there a limit as to the number of breakout rooms? I've created about 5 or 6 breakout rooms, and unless you had a really enormous hearing, like you were the Utilities Commission and you were deciding if a transmission line should go across, 10 municipalities, so you've got maybe 15 or 20 parties. I don't know what the limits are, but that could be found out. I think for most tribunals, you're not going to push the limits of the number of breakout rooms. Okay, so these things I think we've all experienced about how to set up your background for participating using a virtual platform, but it's information that the decision maker needs to give to the participants so that they know how to set up their background. And there's a possibility you can also set up a virtual background behind yourself. So there could be a beautiful tropical scene behind me, but then depending on the technology, I think it uses a lot of the Wi-Fi to the bandwidth to do that. And so I wouldn't recommend that. Can a party enter another party's breakout room, or are there passwords? No. If you are not assigned to a breakout room by the host, and the host would be one of the tribunal staff, you cannot get in somebody else's breakout room. And no, there aren't passwords, but a box comes up on your screen saying you are invited to enter breakout room 1, and then you click and then you go there. You can also, if you're the host, do a test session before a hearing. Absolutely, you do a test session. Later on, we talk about advanced preparation. There's a link to a really nice YouTube video in the resources that gives you some good information about setting up your background. Next slide, please.
Kelly had a quick question about how you would go in camera at a virtual hearing, Carol. I can guess at the answer, but I think it's best coming from you.
Sure. So if you're a party and you want a caucus, just like you would at any time, you say, you know, may we have a 10-minute break and go into our breakout rooms? And the presiding officer presumably would say yes, and then would instruct the staff person, unless you don't have any staff and you're the tribunal and you have to manage the technology and manage the hearing, which can be done, takes a little bit more practice. You then create the breakout rooms. Can you leave a breakout room at any time and come back to the main hearing room? Yes, you can. So just like if we had all broken physically and gone across the hall into our breakout room and came back into the main hearing room, you can do that. The host of the meeting can also set a time limit and end the breakout rooms after a certain amount of time. There's a little clock that plays down at the top of your screen. You can send messages as the host into the breakout rooms.
And just to add to that, Carol, if you're a panel, like if there's more than one of you on the tribunal, it's my assumption you would not leave opposing parties in the plenary session if you were to go in camera yourself. You would separate them as well? Would that be?
You put them all back. You would put them all, if you didn't want to leave the opposing parties in the hearing room and able to speak to each other. You know, many a time I've been in a hearing where the panel leaves and they leave us sitting there. You know, but if you're concerned about something, if it's a very volatile situation and you don't feel comfortable doing that, the host puts them all into the waiting room. And when you're in the waiting room, you are by yourself. You can't communicate with anybody. Okay, we're going to move on now to advanced preparation, and I'm going to look at some of the questions while Adrian addresses advanced preparation, some of which we've spoken to.
All right, so we've spoken about the waiting room, but you have to first select a platform and designate a host. Carol has talked about the host. We have the most familiarity with Zoom, but there are others out there, WebEx, Microsoft Teams, and others. So you're going to have to do that. In the Zoom world, there needs to be one person who is the host who really can control all these functions Carol is talking about: the waiting room, setting up breakouts. If I can't, perhaps you wouldn't run polls, but running polls, those kinds of things. You should, one of the things that you should do, and this is what the Alberta Labor Relations Board has done, so they've developed instructions to the party. So this has gone out, it's a public document, really it's a practice direction that sets out what their expectations are and how they're going to run the process. One of the things that these should include are what we call session norms. So kinds of principles that will govern how the session will run. So for example, that they should have to use video because there may be problems if you cannot see the party. Alberta Labor Relations Board has said that witnesses, when they're testifying and counsel, should all be visible by video throughout the hearing. But you should give them some instruction about occasions when they may validly want to be off the video for a moment to do something. But generally speaking, they should have their video on. They should not be doing something else at the same time, should be focused on what's happening on the live stream. Personal technology should be off or muted, so they should use it only to address emergencies. Should also, as was done for this lunch and learn, get parties to join in advance so the session starts on time, and also make it clear that there's to be no recording of the hearing. A good practice is to run practice sessions with the parties. So they may be run by someone else in the tribunal staff, may not need to be the tribunal itself, but they should ensure that the parties can do what they need to participate in the hearing process. Another good practice, I think we should go on to the next same slide, hold a case management session. A case management session to review protocols and answer questions. So if there are non-live stream issues, the kinds of process issues you'd expect in a live hearing or an in-person hearing, you can deal with those. You should invite them also to deal with the live stream issues in advance. So any tech, what happens if there's a tech failure, advise them to join early so they can deal with the tech issues before they start, and indicate that they should try to attest at least 2 days beforehand so they can fix any problems there may be. So they have, for example, the appropriate software, they're familiar with it, the security issues have addressed, they have the password, the parties can minimize background noise. And I don't think I stress strongly enough, you should test in advance before the hearing everything. So if there's video, what you see and what they can see, and sound issues, so you need to test what you hear and what they can hear. Not unusual to come into a Zoom session and someone doesn't have, for example, a microphone that works as well as they think it does. And that just is going to waste time and cause issues during the hearing. So you should try and canvass those things in advance. Breakout rooms, one practice that we like to encourage is that if you're going into a breakout room during the course of the hearing, you make parties aware of that you're doing that. So you're going to tell them that if you're going into a breakout room during the hearing, that you're going to tell them you're going to come in. If you're using breakout rooms, you set up one for each party or intervener, all their counsel and representatives, for example, that will be used throughout the hearing. And you explain some of the things that Carol has done about the breakout room. So for example, when they're in their breakout room, no one can hear what they have to say, and they can't be seen by other parties. And explain things like how to exit the breakout room, how the host can broadcast a message to all breakout rooms, that the chat function works in breakout rooms. And if you're not using breakout rooms, parties who wish to caucus will need to turn off their audio and video and call each other on the phone during the hearing in order to communicate. You should also explain the use of the waiting room. A lot of this, I think, has been covered already, so I won't repeat what's been covered already. I guess one point to note is that everyone's on mute until the arbitrator makes opening comments, and you should explain how waiting room will be used for witnesses. Process issues. I want to stress again that a lot of the process issues will be the same as in an in-person hearing. So if you have a process where you have examination in chief, re-examination, cross-examination, that will be the same. You're going to have to deal with the complications of dealing with documents. So I know the Alberta Labor Relations Board has asked that parties provide their documents at least 3 business days in advance of the hearing. You should tell them things like how they will object, because that can be complicated, making a signal, especially if one of the parties is self-represented. So you should have some instruction about that. How you will govern the hearing from the parties during the hearing. What is the order of presentation? Make sure that parties should interrupt only when necessary. You should deal with things like how private and sensitive information will be shared, how any interpretation issues will be dealt with, and how documents will be addressed. So for example, if there's a book of documents, you may well be sharing the screen, if for example it's a Zoom platform, and how you'll be dealing with documents to which the parties object. So there should be some advance notice about documents that there'll be objections taken to, and how you will deal with those, or documents that come up during the course of the hearing will have to be exchanged by email in some way during the hearing so the parties can review them. Physical evidence, you'll have to plan for those things too. So by this, I mean things like plans, models, objects, things that would be easy to deal with in a live hearing. You're going to have to find some way of allowing the parties to examine those things. Witnesses, we'll talk a bit more about credibility in a moment, But in terms of the technology part, suggest things like pulling the camera back so you can see more of the witness, set up so you can see their hands, have the witness show the room so the decision maker can see that there's no one there assisting them or prompting them. They have no notes. And you should also ask them to have identification available so you can identify them. Another thing you should try to avoid is the tendency to be more casual because you're not in the hearing room. You should talk in advance what to do in the case of a technical failure. So, for example, calling a particular number or email so that you can tell people what to do. Will the public attend? I think Carol's talked about this already. You should prepare for things like distraction of people coming and going, however, during the hearing. If you're running on some Zoom platforms, you'll see people coming and going on the screen, so you should set it up so that you can't see those people. If they're closed sessions, you perhaps during the in-camera thing, so Carol's talked about putting those people in the waiting room during those periods. And you should also make sure you have thought about how much time you're going to need and whether there'll be any other adjustments to the procedure. So some of the directions we suggest you make to the parties at the hearing, as I say, no one is to record the hearing or use screen captures. So we don't want independent record of the proceedings. No one who is present other than shown. So as I mentioned, no one is off screen helping a witness. Everyone is muted except those necessary. So the witness, for example, would not be muted when they're giving their evidence, but counsel who is not asking questions of the witness would be muted. No one is to use the chat function for messages. So no message going back and forth between parties, and nothing is given, especially to witnesses, to assist them. I see a question about the chat function. The chat function is public. So if there are the chat function is being used by someone, it will be easy to see that it is, and a direction can be given. And I think as far as the witness being by the witness's self, as I say, the camera would be used to check what's in the room going on. It may be prudent to do that at various points during the course of the hearing, or if you have any sense that that's changing, that you ask the witness and again get the camera to be used to make sure that no one is present. How to deal with the loss of connectivity, I've spoken about. How you will be taking notes. So you may prefer to use your computer for notes. You may prefer to not control the hearing process and have someone else do this for you. You should deal with that in advance and tell the parties in advance what you're doing. Also, ensure that people are speaking one at a time so that there's no lag time due to technology. Carol, are there any questions that you want to answer before we go on to the virtual etiquette part?
Sure. There's a number of really good questions that I've been jotting down. So the first, this is in sort of no particular order, just as I jotted them down. Someone mentioned that the use of a virtual background for a witness would allow them to have someone behind them that we couldn't see coaching them with their answers. So yes, you probably would not want your witness to have a virtual background. Very good point. Can the host mute the breakout rooms? Yep, that you can mute all participants. The host can do that. Would you want to use the function in the virtual platform to record? Yes, you, the tribunal, would be the only one that would want to do that. That's why in Adrian's directions to the parties that nobody else does the recording. What would you do if a person refused to provide an email? Well, that is a problem. Then the only way that they could attend would be to phone in. And that might be okay if they're just an observer, they can then listen to the proceedings. But if they're a witness, I think that's a problem. And I think that the staff person working with the parties ahead of time to make sure all the technology works would suggest to them that maybe they set up, let's say they were concerned about giving their email address because, for for whatever confidentiality reasons that they have, set up a Gmail address, email address, that's just for the purpose of this hearing. So it's not their regular email address, it's just they're only going to use it for this hearing. So again, there are things you can do with for people, but it's all got to be done ahead of time, not the day of the hearing. Can the host broadcast to breakout rooms? Yes. And someone suggested use teleconference for the caucusing meetings if you don't have breakout rooms in your technology. Yes, you can do that.
You could use the chat. I see someone's asked to use the chat function in advice of technical difficulties. Absolutely, that makes a lot of sense.
Yes, that is something that you can do. But if you've been kicked out of the platform, you can't use the chat, right? So you're going to have something that involves them phoning a staff person, phoning the host. Okay, the chat, I've seen it being used in different ways. Some tribunals, no, we're not using the chat at all for anything. Others allow the chat for limited things. That's something you're going to have a discussion with at your tribunal. And you may try it and it may not work, and so you'll try something else. Should the host be visible? So you see in the screen that Karen and the two folks from Adria are not visible. My suggestion is that the host not be visible, because it relates to the concept of what people are calling it Zoom fatigue. So it's just yet one more visual stimulus for our eyes. If that person, lifts up their beverage and takes a sip, they turn their body. It's one more stimulus for our eyes to process that we don't need. So I think it should just be the logo. So we know that they're there and they're listening, but they're not distracting to us.
There's a question. Go ahead. There's a question here about tribunal panel members communicating with the chair during the hearing. So the chat function allows for private messages as well. And that would be one way to send a message from one member of the panel to another.
Right, because otherwise you can't slip each other a little note as you might ordinarily do if you're sitting next to each other. So there was also a question about how can legal counsel and the witness be present at the same time? Well, sometimes people might want to use a larger boardroom and they've got one person at one end and another person at the other end, so that they're socially distant. You're going to have to test that so that you don't have feedback from two microphones close to each other. That's one thing. But I think what most of us are thinking about is if I was the lawyer and Adrian was my witness, I'm in Edmonton, Adrian's in British Columbia. We are both present at the same time because we are here virtually. So.
And we can communicate again using the private chat function if we want to, or we could communicate by telephone outside the Zoom platform.
Yes, and if we needed to speak longer than just a chat, we would ask the presiding officer to put us in our breakout room, ask for a pause. Managing background, so next slide, please. So managing background noise.
Just before you leave that, Carol, I just wanted to thank Adrienne and yourself for all those cautions. I think they're very valuable. It occurred to me as I looked at the two of you, because I could see you in person, that you both have doors behind you, and I thought Adrienne's suggestion of sort of scanning the room with the camera to show that you're alone was good, and actually maybe even having the door as a backdrop for the virtual hearing is also another way of ensuring that no one accesses the room. I suppose it's fair to say, though, that in a virtual hearing, and no pun intended, it is virtually impossible to make sure that no one is recording or using a cell phone device in any description. So there's a a certain amount of trust that you expect from the parties, and the only way to circumvent that completely is to actually have an in-person hearing. Is that a fair assessment?
Well, I would say that even with an in-person hearing, there's a lot of these things that would still be possible. So let's be realistic about that as well. Go ahead, Carol.
Yeah, I was just going to say the same thing. I've got my cell phone here. It's muted, but it's sitting beside me on the table. If we were in person, you would never know if I had some kind of recording thing going on. So there is an element of trust. I think that one of the main things about virtual etiquette, as we all get used to this, the one that resonates for me is to be patient with one another. Some of us adapt to technology faster than others. Some of us, need to be asked for the 15th time, please show me how I can have one document on one screen and one document on another screen. That's me. So that's one of the biggest takeaways is let's just be patient with one another as we all work through this. I think one of the other thing that certainly the witnesses will need reminding about is to turn their microphone on and off, and the audio lag that there's just that moment before the technology switches to allow the next person to speak. Next slide, please. Okay, here's another thing that you need to sort out a little bit in advance. If you're a tribunal that takes its evidence under oath or by affirmation, you have to chat with the parties in advance about that, because you can deliver the oath. If Adrian was the presiding officer and I'm the witness, he can deliver the oath to me or the staff, if the staff person does it, in the ordinary way. But I have to have a copy of my holy book with me and hold it up and show Adrian, right? Because if we were in person, Adrian would have the holy book and would present it to me and I'd put my hand on it. So it's just one little thing that needs to be ironed out in advance. Adrian's already mentioned that you can have the person hold their driver's license up to the screen. Witnesses need to be in a private location. Yeah, and one of the questions was, how do you minimize background noise? Again, that's part of the advanced planning. The staff person needs to sort out with the lawyers or the witnesses, the parties if they're unrepresented, what they have behind them. And there was a very good question earlier. What do you do if you find yourself tending to make judgments about a person because of what's in the background? And this resonated for me. I was teaching for the foundation last week, and one of the participants was clearly in their basement, and what was behind them was, it was just a mess. It was just a hot mess. Piled up boxes, a set of skis, winter coats, Christmas decorations. It was very distracting. And the mess, it tends to, as a viewer of that, you tend to wonder, does that mess represent the clarity of that person's thinking? So how do you deal with that? Well, in advance, if the staff person can, someone says, I've lost control of my screen, all I can see is you're presenting. Oh, so there's a technical question for you, Paul, sorry. If you can make the background less distracting, and then, it's the same thing as anything else if you're a decision maker. How do you deal with that? Recognize that that's happening to yourself, self-regulate, and focus on the witness's testimony, not what we see. But I experienced that last week. One of the biggest advanced preparation things is documents. Many tribunals are spending a little more time and emphasis on this than they would in an in-person hearing. And they're even going so far as to having the participants work on an agreed volume of documents, have the numbering of the PDFs done in a certain way so that if you say go to page 89 of the PDF, if it's searchable, you just put in 89 and everybody goes there. So you need a little bit of extra work. And you as a decision maker, you might want to think, if you're going to do a lengthy hearing, can you actually do it from your laptop screen? I have my laptop in front of me, but I also have a bigger screen here that my camera is mounted on. I just got too much eye strain when we all started working from home, just looking at my laptop. So if you're going to be in a week, 2-week, 3-week hearing, which I'm going to be this fall, then I think you need to think about your own setup. So we've somehow lost the PowerPoint. Usually when we lose things, it's because I've hit a button I shouldn't hit, but I'm not in control of the PowerPoint. So we're back. Okay.
I've asked Sandra to put the speakers up on occasion, Carol, so you might see your face pop up if you've been talking to a particular slide for a while.
How can you deal with submission of new evidence during a hearing? Okay, you're going to have, well, this one's going to be a challenge. You're going to have to use some email because, Adrian and I are the two parties, and Adrian is the bad person who wants to introduce new evidence at the hearing not previously disclosed. So Adrian would have to email to me, where the panel doesn't see it yet, the new document. I would have to look at it, see if I've got an objection. And then we would have to Adrian would make his pitch to the panel on what this document is, why it's relevant, why it should be entered into the hearing. I would respond. The board would decide, assuming the board agreed to let it in. Then Adrian would probably also email it to whoever is the host of the hearing, the staff person, to look at the document. If once the board had chosen to admit it, Adrian could share his screen and show us all the document. So I think that's how you would deal with it. I'm going to turn the floor over to Adrian.
Answered a few more questions. There's a question here about why have a witness provide identification if that's not your practice. I think the reason for doing that is to cover the situation, for example, where you have not particularly good video transmission, and you may not be sure that the person who is on the other side of the video is the witness. So it may not be necessary in some cases. You may be quite satisfied that that's the person, but it wouldn't be unusual in my experience with these platforms to see someone who doesn't have very good video, and you need that to be absolutely certain that that's the person who is that they say they are. There was also a question about how you deal with simultaneous interpretation. I think it will be possible to do simultaneous interpretation over this platform, but I suspect it probably would be challenging. You probably are going to be looking at consecutive interpretation, but I wouldn't want to say that simultaneous interpretation was impossible. I think depending on the quality of the sound coming out of the witness's microphone, it may be possible for the witness to speak, and perhaps you could even have that witness speak and be muted on some other technology so the interpreter could speak. I think that's one of the issues that we are going to have to spend some time working through. So I want to just continue on with the next subject area, which is Zoom fatigue. And as Carol mentioned, this is a stress that's created by a few sources. One is the stress of seeing yourself on camera. It gets tedious after a while. Another is the sense of constantly being on camera, that you have to be thinking about what you're doing, thinking about the people may be looking at you, managing what you're doing, trying to act natural. If you take any training on this sort of stuff, people tell you where to put your camera, where to look at the camera, and that can be, for people like me who like to fidget, that can be a challenge for a prolonged period of time. So that can add to the stress. As Carol mentioned, is trying to look in a computer screen. So one thing that we have done at the foundation is try to increase the number of breaks, shorten the sessions. So instead of having a full day class, we have half day. We have instead of 2 full days, you have 4 half day classes. And it may be that you would have to do that with your work as well. If you could set it up that you had, say, a morning panel and an afternoon panel, that might be one way of managing this. But you'll have to think about how to manage that as one of the things you're going to have to deal with. Assessing credibility, I mentioned previously that's going to be a challenge or something you're going to have to deal with in the Zoom hearing world. I must say, when Carol says that I'm bullish on virtual hearings, one of the reasons is that I'm skeptical about the benefits of in-person hearings, and one of them is this feeling that we only can assess credibility well if we are in person. And if you do a lot of assessing credibility, you'll know that there are about 6 or 7 hallmarks of assessing credibility. Things like consistency with other pieces of evidence, opportunity to observe, motivation, and others. Appearance and demeanor, which is the only real advantage when we're talking about assessing credibility in an in-person hearing, is only one of those tools. And I think generally now we say that that is the least reliable means of assessing credibility. But if you feel that assessing credibility is an advantage to an in-person or to a hearing, then you should try to set up your hearing so that you take advantage of what the technology provides. So I mentioned some of these before, like having the camera look around your room beforehand, having as good a quality camera looking at the witness. I mentioned some of the things like showing as much of the witness's body, I guess, as you can. But there have also been some strong statements from the courts that the use of technology does not give rise to unfairness and that it can be assessed using a virtual platform. Can you move on to the next slide, please? So here's one of them. And this judge said that there's no due process concern because all parties have the same opportunity to participate and to be heard. Everyone has the same ability to put their same relevant evidence and to challenge evidence adduced by the other party. And the only possible unfairness is the lack of comfort by one counsel that they will be at their best in presenting evidence and making arguments using technology. So that's sort of the general kind of due process concern addressed by the court. We're all in the same place, and as long as we make the possibilities available, we can present evidence just as we could in in-person hearing. Next slide, please. The other one is a stronger one about credibility, and I think this is a really interesting perception of it, and I think especially if you have a large monitor screen and a good camera with the witness, you may well be able to see more of the witness on the virtual platform than you could in person. So, and in fact, it may be an advantage to reduce the chemistry which may develop between counsel and the witness. That may be a pro or a con depending on the circumstances. Next slide, please. So we have a further poll here. Could you run the poll, please?
While the poll is being gathered, Adrian, I have found we've been using Zoom for quite a few years at Adria, but I must admit, with the larger screens we have now, sometimes when I have one-on-one meetings, I almost feel like the person is inside my personal body space or bubble, and like, please sit further away from the camera. So it is an interesting tool, but I did like what you had to say about, maybe you need to see their shoulders or who's left and right of them or their hands. These are really interesting points that you made earlier.
Thank you. So you can see there's an overwhelming support here that virtual platforms for hearings will continue even after social distancing is relaxed. That certainly is my perception of it. Amongst other things, I find it hard to believe that funders of administrative justice, now that we've run hearings this way for this long, are going to accept the argument that we have to do hearings in person all the time. We've managed to adapt, or we will manage to adapt, and so this is going to be the reality for many of us going forward. I'm told there was a poll we missed earlier on, so if you wanted to run that one now, this would be a good opportunity to do that. Poll number 4, I believe it was.
Mm-hmm.
And this is to deal with the credibility issue.
While you wait for that, Adrian, I'm just wondering, do you ever sense that there's a difference sometimes between one party who might be presenting, up close and personal, and another who might be sort of in the distance, a tiny head on a big screen? Does that put one party at a disadvantage? Is that something you try to equalize during your preparation phase to make sure that both parties are sort of presenting equally visually?
I don't know that I would necessarily as a decision maker, give the parties advice on that, but I can't think that it wouldn't have an impact on the way the decision maker sees things. So if I was advising people, say as a lawyer or someone else, about how to run a virtual hearing, I would certainly be telling them that that would make a big difference. And you should be thinking about it. So here are the results, and then Carol can comment on that in a moment. So here's the results of the poll. Interestingly, and I think that is the most important one, if one is to sing all these out in most cases, consistency with other evidence, I think, is what we do tend to look at most when we're assessing credibility. I see people look at demeanor as being a significant one, probably, I guess, number 3 after ability to recall detail. So I think we're seeing that witnesses' demeanor is something, and body language, I suppose, are things we don't want to lose, but a recognition that probably there are, I guess, at least 3 other, I see witness, a direct observer of the event, so at least 3 other things that we would look at and perhaps give at least as much weight to that. So that, I think, tends to support the notion that we can assess credibility without in-person hearings. Carol, I think it's over to you now.
Thanks. I've got a number of questions. Just where I want to comment is Paul's observation that sometimes it feels as if the person, because of the way they have their camera set up, is in your own personal space. And that's something that people that have written about how we process information in this environment have commented on. And there was an interesting question from someone. So what if so my witness is testifying, they look like Adrian looks like, and the other lawyer says, I want Adrian to back up, okay? How would you as a decision maker deal with requests like that? That's a very interesting question. I haven't experienced that yet, but as I'm processing it, I think that it would be one of the things that you would address in your practice sessions. And so long, you as a decision maker, so long as Adrian's camera setup meets your minimum norms as a decision maker, okay, that you can see him relatively clearly, that he's not backlit, because the light's coming in from a window behind him, that, it's okay, basically. Would really we see anything different about Adrian? We might see we might see his hands if he was sitting behind a table. But probably, let's say he's an expert witness and he's got his 150-page report in front of him. So all we would really be missing is him looking at his report, to address questions. The other thing that someone asked me about was a concern that on judicial review of a virtual hearing, that one of the grounds for judicial review is a lack of procedural fairness. And yes, that's correct. I think we've got a strong indication from the courts. They too are using this mechanism. And one of the cases that was quoted from was from Australia. It was a 6-week trial with 50 witnesses. And the message from the justice was, this is our world, get on with it. So, it's going to be the rare tribunal that has something more complicated than that.
Well, let's face it, we don't know how long this world has been going to be going on.
No.
And I think courts are giving the message that we have to get on with it as a matter of fair process for everyone. It can't be, in other words, a means of stalling.
One of the things that you could do, if you develop some written material that you send out to the parties in advance to tell them about what your expectations of them are in this virtual world, and you have some of those expectations repeated again in the opening comments of the presiding officer, I don't see anything wrong with attaching those as an exhibit to your decision. Because if it becomes part of the record of your decision in terms of, this is what we advised the parties on how it was going to be in the virtual hearings. And remember, tribunals, you control your own process. So, and the courts have communicated that this use of this technology is not inherently unfair. Someone did ask about, and I want to pick everybody's brain on this one because I don't have a lot of background in it. Adapting to the cultural sensitivities, for example, of First Nations communities and the use of this technology. I'm going to check some of the questions, and Adrian, do you have anything on that?
Well, I would say that you're going to see a diversity of, it'll be like any other community in Canada. You'll have people, elderly people, for example, who will have a problem dealing with technology. You'll have people from some cultures who have difficulty dealing with technology. On the other hand, you'll see a lot of First Nations organizations that are quite experienced in dealing with technology. I've been around a lot of the Arctic. I remember in the early days I was there, seeing some of the uses that were being made of computers back then, artistically and otherwise, was really, as sophisticated as anywhere. So I wouldn't want to sort of make any assumptions that First Nations communities couldn't adapt to it. That's not to say there won't be some who will, but I would expect that it wouldn't be on a First Nation to First Nation basis. It'll be individual to individual, just like it'll be with some, as I say, elderly people, or even people who just have a real thing about technology. That is something that we're going to have to deal with as a society as a whole, and not just with any particular part of it. I see there's a question also about accommodating special needs of witnesses in virtual hearings. So I'll tell you right now that I wear hearing aids normally. And so I take my hearing aids out and I put these earphones in because I find that's the best way to communicate by Zoom. So that's certainly my accommodation to dealing with a hearing issue. Eyesight, I can't say any particular experience with that, but I think you could accommodate by that, by the type of monitor you use, and making something available so that people can see it. Physical disability, I think it may well be easier to accommodate here than in a courtroom facility, because you can set it up so that people are in their own place, giving evidence that they have physical disability issues, and be more readily accommodated. Their speech issues, I would expect, are going to be similar as hearing issues, in that it'll be potentially the type of microphone. It may be, I mean, you get it. I get it because I have hearing problems, sometimes hearing people with accents and things like that it's a challenge hearing them. And I think it's just like anywhere else, you have to sometimes ask people to repeat themselves, or find some way of working around that. Those are challenges I think you would face, as I say, in an in-person hearing. Carol.
Adrian, it's Paul. These are all issues that I assume you would deal with in preliminary discussions before the hearing regardless. And I think that's always
right.
important.
That's
I think
right.
it's also an important opportunity to remind the audience that there's some important jurisprudence out there, pertaining specifically to arbitrators, but I would assume that it would pertain to hearings and tribunals as well, about not doing your preliminary sessions just with one party and then separately with the other party. It's important to make sure that all the parties are in the room at the same time. And so for arbitration and administrative justice procedures that you're speaking to, that's very, very important. And some arbitration awards have been overturned on that basis alone, just purely administrative discussions that went on, but only with one party. Differs quite a bit, of course, from mediation, where the mediator can use the virtual tools to have one-on-one conversations with each party before they convene in plenary.
But having said that, you could have staff, as long as it's not the decision maker, you could have staff working separately with the parties. It's the important thing is that the decision maker, those who are actually going to be making the decision, aren't the ones who are dealing with the parties before the hearing in that way. Carol?
A couple of points. Is it possible that at some point tribunals will loan computer equipment? Maybe. Make arrangements with libraries, assuming that they're open? Probably. Or maybe some other type of government office or another type of tribunal, maybe the municipal office, might have some space and some equipment that someone can go in and access. That's all upfront work. Deborah Simmons was very kind to put on the chat link, the chat function, a link to a Zoom article about about translation. So that was a good question. And is it, if an appellant wishes to attend by telephone only, is it acceptable? Is there a greater credibility concern in doing phone only? You may have people, and I've experienced this because we've been teaching a lot in the last 2 months using Zoom. One day a participant can access the video and the audio. The next day they keep getting kicked out of the Wi-Fi kicks them out, and the only way they can participate is no video, just audio. So you may have this type of a connectivity issue. Assessing someone's credibility using only their voice. Again, it goes back to how does that testimony line up with the other testimony on that point? Okay, that's going to be your biggest tool in evaluating the credibility of that witness's testimony. I have only cross-examined someone once on the telephone. They were not a very key witness. They were more of a peripheral witness, so it wasn't as big an issue. I have never had to yet cross-examine a really key witness using only the telephone. Has anybody had that experience? What about yourself, Adrian?
I've cross-examined someone on the telephone and it wasn't a very satisfactory experience. I mean, I think as a decision maker, in a lot of circumstances, you probably could insist that they do attend by video. It's not like being in a course. So that that's probably something that you're going to have to set up in advance to make sure that they can testify as much as you can. You may get put in a situation where it's very difficult to hear their evidence otherwise. And I guess all I can say is that then you probably should be even more careful if you can about things like no one else being present and checking what's in the room and all that stuff to the extent you can. And you may have to be creative in some of the solutions you come up with. Perhaps having someone as a supervisor there to watch that that's not happening. Yeah, certainly it's a challenge. I think my best advice would be that if you can insist that they're on the Zoom call in some way available by video, that will be the best solution.
Right. A few questions. Yes, there's hearings and then there's hearings. So you may hold a hearing for the purpose of perhaps dealing with an adjournment request, or because you're fighting about when the hearing date should be, or some sort of preliminary type matter. And yeah, those have been happening by teleconference for a long time. I think the question related to, what I was thinking in my mind about a witness giving evidence only by telephone, was the ultimate hearing where you're receiving the evidence about the issue that you have to decide.
And credibility is going to be an issue.
Correct. Post-hearing, we usually deliver a written decision. In a virtual world, do you issue decisions in a virtual appearance? Does it help or hurt? I think in the virtual world, if your practice is to issue a written decision after the hearing, after the decision's been made and written up, you're going to follow that same process. And this is a good question. Do all the decision makers, so if Adrian, myself, and Paul were the 3-member panel, do all 3 of us have to be visible at the same time to the parties? I think yes. I think, Paul, there have been a few times when you have gone off camera for various reasons. I think it would be the same thing as if, Paul, you got up from the hearing table and walked out of the room, okay? The presiding officer should immediately be calling time, because remember, one of the principles of procedural fairness, they who hear must decide. So that also means that you are present throughout the whole hearing. So if Paul gets up and all he's doing is going out to get a document over here, but he's gone off the camera, we don't know where he's gone. So yes, I think you all have to be present.
And that applies to that same question, similar question at the bottom there.
Yes.
What should a panel do if one of the members loses video connectivity? You can't continue. All the panel members should have the same information available to them.
Okay, so we've been answering the questions. Let's just go to the next couple of slides, please. Checklists. Okay, if you could go to the one with all the coloring, that looks like my type of checklist. So in the resources that we've given you, some of them we've highlighted that there are checklists attached. So other people have gone to a lot of work, and we've given you links to those resources. They've got technology requirements. Let's say you only have an iPad. That's what you have. Sometimes some of the features don't work. So for example, I don't know why, but I had someone in a course, they couldn't share their screen using an iPad. Don't know why. That's just what was happening. So that's part of the practice. There's a case manager checklist. So that would be the staff person that is working with the parties to get all of this organized. A presiding officer checklist and a checklist for the parties. And yes, the resources are part of the presentation. Next slide, please. So the concluding remarks: prepare, prepare, prepare. And then get familiar with the technology. There's no question. And if you as a panel member are not fortunate enough, or your tribunal doesn't have that large a staff, that you have a staff person that can dive into this and be the troubleshooter and do all this work. If you are not holding a lot of hearings, you may think about going to some of the court reporter services. They will be your technology person for you, okay? And it's not that exorbitant of a cost. So that's a suggestion if you're only going to do 1 or 2 hearings. But if you see value in this technology on a long-term basis, then someone's going to need to invest and be the main technology guru. Next slide, please. So I think this is some of our wrap up. The copy of the PowerPoint is going to be sent out. I think that Adria is also sending out an evaluation. Paul mentioned some of the upcoming Adria courses. Please go to the Foundation's website for their upcoming courses. I know that there's some courses on the principles of administrative justice coming up, evidence, and others. So please look for those. Very good point. It's important that people on the video not do things that are distracting. And I think that's directed at me because I have a bad habit of twirling my hair. And ordinarily when I'm in it, so and I take your point, thank you. When I'm in a hearing, because I know I have that bad habit, I generally clip my hair back, and I should have done that. And so let's just take a look at the Q&A. Okay, we're good there. Let's take a look at the chat.
So I think the two of you have done a really good job of monitoring the Q&A and the chat as we progressed, but there might be a few unanswered questions. If any of the participants felt that their question has gone unanswered, I invite you to resend it. But we do have about 10 minutes left to take questions, and of course I'll conclude with an opportunity to thank the two of you.
I think there was a question some time ago about what do you do about recording or about producing a transcript. So one of the resources I think that we referred to was some material that one of the court reporting services provided to us. So, I mean, that's certainly one way you can produce a transcript is have a court reporter on the hearing creating a transcript. But you also, the recording coming out of that should be good enough that you could give it to someone else to transcribe it when it's finished. So I would think that either one of those methods would work to prepare a transcript or produce a transcript.
Lisa really wants an answer to her question because I know she was probably the first question that came up. And essentially at the beginning of her organization's first virtual hearing, do you let the parties know that this is the organization's first virtual hearing?
I don't think I necessarily would. I mean, I think it might be something that you might tell the participants as you went on to sort of explain any glitches that came up. But I don't think it's essential you do. I mean, I suppose you could just as a matter of a historical record, but I don't think it's something that needs to be done. Carol?
No, I think that you can, as a presiding officer, acknowledge that everybody is getting used to using this technology. If you've got a question, please ask. If you lose connectivity, like I think just, recognize those things. Like these gremlins happen. I had all my Zoom all organized, had taught the day before perfectly fine. I sign in the next day. I have no audio. I don't know what I did, but I managed to troubleshoot it. So these things are going to happen. And I think it's part of being kind to each other, just acknowledge it and, move through.
There's a question also about, do we think that the technology will encourage the public to attend? And I did see that question previously. I think if I had to predict, and it's just my prediction for what it's worth, I expect you've got more people home right now through this whole thing, and they're looking for things to entertain themselves. And I expect there'll be curiosity, and especially if there's something particularly interesting or perhaps even salacious about what is going on at a hearing, you probably will see more public interest. But I think like everything else, over time, that will dwindle. It may be because it's easier to get in, as opposed to going to a hearing room or courthouse or whatever, that people will find the opportunity to jump in and jump out more often, just like, if it was one of those Senate Judiciary Committee hearings or that sort of thing we're accustomed to seeing from the US. But I expect over time that you'll see less and less of the public coming in.
I think there'll always be a place for the in-person hearing and even a preference for it. But I think much like 9/11, there were residual effects long-term after 9/11. I think there's going to be residual impact here, including, the public got sort of jump-started on the use of Zoom technology. You might remember in March and April, there was a lot of negative press about Zoom, but people have gotten very familiar with how to use the technology properly. Zoom has improved its platform. The other service providers have done the same. People are liking working at home and you know, increasingly comfortable with it. So it is a great tool for access to justice. And I think, personally speaking, I think there will be a long-term demand for it. But we all look forward to the in-person meetings again.
Two good questions.
Yeah.
One in the chat and one in the Q&A. The one in the Q&A was, in what circumstances are virtual hearings or virtual witness testimony not appropriate? My thoughts are, if it's confidentiality is an issue, then it would be managed in the same way that you would manage it in person. You would remove from the hearing room anybody that absolutely did not need to be there. So you might have the opposing expert needs to be there, or the opposing witness, and the client needs to be there to give instructions. They're always allowed to be present. But everybody else is out. You put them all into their breakout rooms, or you put them all out into the waiting room. It's just as if you had a confidential aspect to the hearing. You can still have undertakings from people that they recognize that certain documents or certain testimony is confidential. They won't share it. Adrian, anything else? And then I'm going to look at these questions over here.
On that point, I could see security issues coming up. You could see organizations who are really concerned about security being concerned about virtual hearings and trying to find some other way to run them. I see a question here about, we run 12 hearings on one day, one right after the other. Do you think this technology can handle this? What if we run 5 minutes late, for instance? So yes, I do think the technology can handle this. In fact, it may well be more efficient than doing it in person, because you can go from one to the other fairly efficiently. And the running 5 minutes late, that's one of the advantages of the waiting room. People come in, you can see what's happened, for example, in this webinar, the way that's been managed by Paul and his staff, being able to manage people in the waiting room and getting messages out while we're going along. Very easy to handle with technology. So yeah, you say we're running 5 minutes late, you send a message out to the waiting room, people know that. Or you could send messages, you could have their cell phone or emails available and send the messages that way. So many ways, I think, to manage those kinds of issues. Paul.
So just a reminder to everyone, we have a hard stop in 5 minutes. So that gives you about 2 more minutes to put your questions in. I noticed that Kate has a very excellent question about SLRs, or SRLs, self-represented litigants. And then I will take the last 2 minutes just to convey our thanks.
So I think we dealt with a little bit of self-represented litigants, but I think a big part of it is the pre-hearing meeting with them, to get the technology issues lined up, to try and anticipate some of their concerns. And a lot of the issues with self-represented litigants are going to be similar to the ones that you have in a live hearing, and that they're not familiar with the process. So, some of it is going to be education you give them anyway in the process. But I think a big part of what's going to be different here is to get them educated on some of the technology issues, and telling them things like, you're going to have them move the camera around their place where they're going to be giving evidence. Not that you necessarily doubt them, but just to reaffirm that they're the ones that are giving testimony. I think probably the biggest thing is to think about the kinds of issues that you could come up with, and try and deal with them in advance, and probably give them to them in writing as much as you can as well. Carol?
Agreed. It's all about work up front. There's no question. There was a question about doing some of these little more advanced things in Zooms, like creating breakout rooms. Yes, some of the links that you will get in the PowerPoint take you to some Zoom and WebEx resources on how to do some of those little more advanced things.
Okay, I think we're gonna do our wrap at this point. So just a reminder, if you were late logging on, we will be posting the recording of this presentation on the ADRIA website, likely within a week. And our last 3 luncheons are also posted there, along with some other webinar opportunities. So feel free to go to adralberta.com and check that out. We look forward to our next luncheon presentation. Again, that is August 11th with Dr. Darren Lund from the University of Calgary, and he will be talking about opening uncomfortable conversations on social justice issues within your workplace. FOAJ newsletters, Adria newsletters, these are things you can subscribe to keep abreast of training and webinar opportunities. We've enjoyed putting these on for free. We've obviously attracted a tremendous audience, and we really appreciate over 200 of you are still online participating in this. It's been really great. Darren and Carol, I can't thank you enough for some really valuable points. It's amazing that no matter how much you think you know about using the virtual tools and doing mediations, arbitrations, tribunals online, there's always something you haven't thought of. I mean, I was even reflecting on my coffee mug here, thinking that if all anyone sees is the picture of Donald Trump, you know, what does that say? How does that color their impressions of me? Do they think I'm a Trump supporter? Because if you can read, you know, if you read the small print, I clearly am not, and I'm not going to get any more political than that. But these small backdrop issues and little things that clutter up our proceedings are, you know, really valuable. So I thank you for the many points. I think at this point we would normally hear thunderous applause. I do encourage the participants to send in your final comments and thanks using the chat function. And of course, we will be in touch with all of you. So again, my sincere thanks to Adrian and Carol for taking valuable time with us today, sharing your wisdom and knowledge. We've all, I think, gained from the experience, and my thanks to you both.